We are here at the Minnesota Senate Property Tax Subcommittee meeting, Wednesday, February 23rd. We do have a quorum and I call the meeting to order. This morning, we're having a presentation from the Minnesota Department of Revenue concerning Rule 8100. This is regarding state assessed property. And we have a couple of individuals with us. First, I will go to Mr. John Klockseem, Assistant Commissioner of Tax Policy and Public Engagement. Welcome, Mr. Klockseem. Please identify yourself for the record and you may begin when you're ready.
All right. Good morning, Mr. Chair and members of the committee. For the record, my name is John Klockseem and I'm an Assistant Commissioner at the Department of Revenue. With me today is Beth Johnston, Senior Policy Advisor. We wanted to take this opportunity to provide you an update on where we are at with the review of Rule 8100. I want to say update because we still have work to do, but right now is the perfect time for us to pause and kind of inform you of where we're at, what we've done, and what we plan to do. So I'll start with some background. In Minnesota, all property must be valued at its market value and must be separately and independently valued. Generally, property tax is assessed by local taxing authorities. The legislature has created several exceptions to this arrangement of local valuation. Think of your county assessor, local assessor, one of which is the valuation of utility and pipeline companies. Revenue must annually list and assess the personal property of utility and pipeline systems as of January 2nd of the assessment year. We must then provide the values to various taxing jurisdictions in which the property is located. Instead of providing an individualized valuation, the legislature has adopted a unit rule method for revenue to value the property of railroads, utilities, and pipelines for tax purposes. The unit rule method values the entirety of a business, including all property, as a going concern when the business enterprise is located in more than one jurisdiction. Revenue promulgated Rule 8100 regarding the ad valorem taxation of utility and pipeline systems. The 2021 tax law requires Revenue to review our process for valuing these properties. We welcome this opportunity. This provision aligns with Revenue's commitment to serve our communities and provides valuable opportunities to better understand stakeholder interests with respect to our work. To ensure efforts to review the framework for property valuation is as meaningful as possible, Revenue partnered with the Specialized Office of Collaboration and Dispute Resolution within the Department of Administration to facilitate the process. OCDR helps stakeholders understand each other's needs, examine shared challenges and opportunities, and maximize mutual gain. Our goal is to create an environment to listen, learn, and work with stakeholders to review the framework for property tax valuation. We started this process with some listening sessions to better understand the concerns of all stakeholders. Revenue reached out to over 400 stakeholders to invite them to participate in listening sessions with the goal of better understanding all stakeholder interests. 137 people indicated that they were interested in participating in this process, and 109 people signed up to participate in a listening session. I will now turn it over to Beth.
Mr. Chair and members of the committee.
Welcome.
For the record, my name is Beth Johnston, and I am a Senior Policy Advisor at the Department of Revenue. To begin the review of the rule, we decided to hold listening sessions to hear from stakeholders about the things they believed were working well and things they do not think work well. We knew we would get a variety of responses and that not all areas will affect all stakeholders. In addition, we wanted to find out what principles and values for centrally assessed property mattered most to our stakeholders. Revenue held 7 90-minute listening sessions in October and November of 2021 and 1 supplemental listening session in January 2022. The initial listening sessions included 15 to 20 public and private sector stakeholders. The listening session agenda was developed by Revenue and OCDR and divided into topic areas that were identified as interest to stakeholders, aspects of the current valuation system that are working well, aspects that could work better, the timing of the valuation process, and resources required from stakeholders. Approximately 100 stakeholders participated in the listening sessions. Representatives from some utility and local governments participated in more than one listening session. Overall, there were 55 stakeholders representing 31 utility and pipeline companies, cooperatives, and associated lobbyist and law firm representatives. 47 stakeholders representing local governments and local government associations, as well as members of the legislature. Next, I would like to share some information we learned during the process. At each listening session, we asked stakeholders to rate these principles from the most important to the least important. The principles were stability, transparency, efficiency, competitiveness, and responsiveness. Participants ranked stability and transparency as the two most important principles for the valuation process. Local governments and companies both value having a tax system that prioritizes stability for valuations from year to year. The chart in the handout shows the full rankings from the 66 listening session participants who completed the survey. We also asked participants to rank these principles to help us better understand their priorities when it comes to a tax system and how these principles apply to the methodology in Rule 8100. We also asked stakeholders to share what they viewed as strengths and weaknesses. They mentioned numerous strengths with the rule and the administration of the rule, and several strengths of the rule were also weaknesses of the rule. These include the administrative appeals process, discretion, communication, and the responsiveness of our staff to questions. The current administrative appeal process is a newer aspect. Prior to the law change in 2017, the commissioner was unable to enter binding settlement agreements with taxpayers during the administrative appeal. The inability of the commissioner to resolve an administrative appeal meant that tax court was the only available pathway for taxpayers to resolve their disagreements with the order of value. This change took effect beginning in assessment year 2018. And while not all cases will be able to be resolved in the administrative appeal process, the number of petitions to tax court has declined since this process became law. Stakeholders from private and public sectors express their appreciation for the process and its ability to solidify valuations within an assessment year. However, the timing of the appeal process is still a concern to local governments, especially those where utility and pipeline property make up a large share of their total tax base. Additionally, a few utility and pipeline companies shared a desire for additional information on the unprincipled settlements that result from the appeal process. Another frequent topic was discretion. Rule 8100 provides for discretion for valuing pipeline and utility company property. Stakeholders share that the use of discretion is both a strength and a weakness of the rule. The discretion provides flexibility to allow for the most accurate assessment of value, but also can be a point of disagreement. The timing for the valuation process was also a common discussion point. There are competing deadlines that create tension within the time frame for valuing state assessed properties, as well as when the administrative appeals process is used. Companies expressed a desire to have more time to file with the department in the early spring. And meanwhile, local governments have statutory requirements to send their truth in taxation notices. The timeline for completing all of this work does not provide additional space and can create stress for all parties. Lastly, we heard from stakeholders that they appreciate the different communication channels that Revenue has developed over the years to keep companies and local governments informed. This includes the spring and fall forums we host each year to discuss topics related to state assessed property and presentations for local associations. We work closely with local governments to develop a virtual room to securely share information when companies have updated valuations during the appeal process, so counties and other local governments can monitor for potential tax-based implication. While there were many things stakeholders appreciate about our responsiveness, we will continue to look for more opportunities to share information and work with stakeholders. We also want to acknowledge that not all stakeholders were aware of different opportunities and information sharing we provide, and we are continuing to work on ways to find and share this material. I will now turn it back over to Assistant Commissioner Klockstein.
Mr. Klockstein.
Thank you, Mr. Chair. So we want to talk a little bit about our next steps. Throughout this process, we've wanted to be very intentional, obviously, you can see that, and thoughtful as we review the methodology. We've been reviewing the information we learned from the listening sessions to formulate the next part of the review. Plan for the next phase of this work is to create 2 work groups to focus on the process and the methodology. We are designing this phase with the Office of Collaboration and Dispute Resolution once again, and they will continue to facilitate these discussions. The process work group will review items not related to the methodology of Rule 8100. This includes items like timeline for evaluation process, administrative opportunities for reporting, communication, and information sharing improvement. While these are not items that are specifically mentioned in the law, we see this as a key opportunity to build stronger relationships with our stakeholders and find ways to improve the process in ways that would not necessarily require a legislative or rule change. The methodology work group will focus on reviewing framework of Rule 8100 and the ad valorem taxation of utility and pipeline systems. We will be taking feedback from stakeholders on how revenue estimates the unit value, allocates value, removes exempt property, and apportions Minnesota value to each taxing jurisdiction. We'll also plan to review some of the components of the rule that allow for discretion and the capitalization rate study. These work groups will consist of stakeholders from utility and pipeline companies, local governments, and associations, including those who previously attended listening sessions or indicated interest in being involved. Our goal is to have equal representation of all stakeholder groups in the work groups. We do not have a set end date for this work because we do not want to rush this process. We expect this to be completed by late spring or early summer. With this, Mr. Chair and members of the committee, we are happy to answer any questions you might have.
Thank you, Assistant Commissioner. I have a couple of questions I'd like to pose. Under the findings portion of the report, the administrative appeals process, it mentioned that a few companies had shared a desire for additional information on unprincipled settlements that result from the appeal process. Could you define for us what unprincipled settlements are?
Mr. Chair, members. Yes, so when we're in these appeal settlement negotiations, some things are very clear that we can make adjustments to that we agree with the company on. Other things are not as clear, and it's those things where we may have disagreements on, but within the administrative appeal process, we can still compromise and reach an agreement on the overall value without laying out the specifics on how we exactly got to that value. And so when we know we have agreements, but it's still in the best interest of the state, we can agree to that for that year and move on.
Assistant Commissioner, when you mentioned that you agree for that year, I guess the question I have regarding those type of settlements or regarding the decisions of the court, have you went and implemented the areas of correction in which the court stated the state was wrong?
Mr. Chair, members. So I think with regard to the tax court decisions, in order to pull out certain items, and I think maybe that's what you're referring to, pulling out certain items within a decision of a tax court, they would have to, for us, be so universally accepted that they could be applied to all these companies, which are different from each other, and applied in a way that would be for years in the future, not relating to that particular year, because by the time you get a decision from the court, it's several years later. But they would have to be these principles that can be universally applied to all these companies. And as of yet, there's been a few decisions where I've seen that. One of those things might be that the Supreme Court has said the rule has the force and effect of law. Obviously, we can apply that to all companies. It fits, but some of these other things have not been so clear.
Well, then, Assistant Commissioner, what principles has the tax court ruled on that the state had done improperly that can't be applied on a continual basis into the future?
Well, I think, it's important to remember that, these things are not, Mr. Chair, these things are not so binary as right or wrong. I think anybody who's practiced appraisal for any period of time knows that there's nuances and opinions in this. And I think that, if you look at certain things within the rule where the tax court has ventured their opinion for that year in that specific case, maybe something like what the cap rate and the inputs into the cap rate are, that might be something that, not universally say that 7% cap rate is applicable for all future years for all companies.
Assistant Commissioner, I understand that cap rates can change depending upon the rates that are charged for the transmission of certain materials through the pipelines, et cetera. But it seems to me that also in the appraisal process, one tends to look at historical background as to what has been the what kind of capitalization rate has happened in the past, and recognizing that it may or may not be that in the future. However, when you have periods in the economy whereby there are certain elements that are present, such now as inflation, et cetera, which might increase their rates, but will also increase their costs. If there was truly a market for pipelines, and we understand that that's very limited in that respect, the historical reference of capitalization rates would be a factor, as it is in the valuation of any other income producing property. So I guess my point is, if we make a correction for the years that the tax court ruled, but then we just continue doing it the way we've been doing it into the future, it seems to me we are asking for continued litigation. And so what is your response to that, Assistant Commissioner?
Yeah, Mr. Chair, I think your point is well taken. I think we want to consider all the evidence that we have for a valuation process that is relevant to that valuation process. However, we must every year consider all the evidence, and sometimes what the previous year conclusions were are not necessarily going to be the conclusions of this year. And so while, the court has an opinion of value, it's important to look at that and consider all the evidence.
One of the other items I know that has been mentioned is the timing. Could you share with us, basically we as private property owners receive our notice of valuation in the spring with boards of review set up with cities and counties starting sometime usually in April and May, and the county review coming sometime in June or July. Do you provide the same timeline for value determinations for utility properties, Assistant Commissioner?
Mr. Chair, members, we do not. Our timeline is a little bit protracted. We still provide a value estimate as of January 2nd, the assessment date for all other real property. But due to some of the reporting requirements for some of these companies, the timeline and the period for getting those values into the hands of the local jurisdictions is delayed. And so I think that's one of the things that we want to look at in this process, along with, I broke it out into 2 work groups. So one of those work groups would kind of focus on these timing issues and see if there is some way that, you know, by the time the local jurisdictions receive these values, that it's not something that's so far into the budgetary process that it ends up being a surprise or something that they have to accommodate.
One other issue, last year, the legislature appropriated $28 million to compensate local units of government for the refunds that had to be made as a result of the tax court altering the state's value. Have you ever contemplated asking the legislature for the ability to set up a reserve account whereby that type of compensation might be made when such errors are found, in light of the fact that we've had an ongoing process of losing court cases in recent years?
Mr. Chair and members, I contemplate a lot of things. I don't know if that's one thing that I've really ruminated on a whole lot, as that would not be within, you know, my purview to do that. But certainly that is an idea. I think it would kind of be a little bit out of the norm of what property taxes has traditionally been, whereas you know, we have thousands of tax court cases every year, not just in the state assessed arena, but also in the real property arena. And then if those should result in a reduction, it is those jurisdictions that levy the tax that are traditionally responsible for refunding that money.
Yeah, I understand, Assistant Commissioner. Of course, in most instances, individual tax appeal cases are not going to result in the kind of dollars that we saw as a result of last year's court settlement. So anyway, members, Senator Klein, Senator Murphy, do you have any questions? Okay. Any other further comments, Assistant Commissioner?
Mr. Chair, first, I just want to say that the department appreciates the legislature allowing us to do this review, and appreciates your time and interest in this subject, and look forward to further informing you as we complete our process.
Thank you, Assistant Commissioner. I assume you will let us know when you are holding that next round of meetings.
We can certainly let you know. It'll be a series of meetings, Mr. Chair. So what we plan to do with these work groups is have these people really focus in on some of these more in-depth questions. So they'll be kind of the same people working it out over a series of meetings.
Thank you. I would have liked to have been online for those meetings last fall. However, I had other items occupying my time during that period. So anyway, very good. If no one else has any questions at this point, again, we thank you for your presentation, and I will declare this meeting adjourned.